This is an application for permission to appeal against a decision of the Court of Appeal refusing the applicants an interlocutory injunction effectively restraining the respondents, and in particular the seventh and sixth and fifth respondents, or fourth to seventh respondents, or some of them, from dredging. The applicant essentially arrests its case on the argument that the dredging being carried out by the respondents, as I will call them, although they are actually interested parties, is contrary to the Conservation and Protection of the Physical Landscape of the Bahamas Act, Chapter 260. If, as we conclude, it is at least arguable and strongly arguable that the 1997 Act applies, Mr. Knox contends that valid consent was in fact given under that Act on the 23rd of January 2014, but that was consent given by the Acting Director of the Department of Lands and Surveyors, as he himself accepts effectively as the landowner, and in that connection, therefore, it seems to us that it was not a valid permit under the 1997 Act. It was given by the wrong person, namely not the director of the DPP, and it was not given in the belief that the 1997 Act applied. When this application was first raised, there was no permit under the 1997 Act. But overnight, a permit dated 22nd May 2014 was produced. On the face of it, if this is a valid permit, that is the end of this application. And while it may be a valid permit, we are bound to say at this stage that there are reasons for concern over it. In particular, it's clear that a permit of this nature an application for a permit of this nature should be seriously considered by the DPP. Such a proposition goes, one would have thought, without saying. And one notes that before such an application can be granted, it would appear from Section 8 of the 1997 Act that the DPP should at least consider whether he should allow any interested person to object, and if he does, he should take into account their objections. There is evidence to suggest that this dredging and the eventual project with which it is connected is very controversial and has been the subject of a not entirely favourable, I think Miss Jordan, who appears for the applicants, would say that that is putting it far too low, not entirely favourable environmental impact assessment, and has various other criticisms from other people. Given the very, very last-minute nature of this permit, we consider that there must be a question mark over it and as to whether it is valid. In those circumstances, it seems to us that there is an arguable case, both for the applicant saying that, a strong case for saying that there is a need for permit, and a reasonable case for saying that the permit that's been produced at the last minute is not valid. In those circumstances, it seems to us we are faced with a balancing of injustice or convenience argument. Furthermore, it can be said in favour of the respondents that they did apply, it would appear, although the evidence is somewhat scanty, for a permit under under the 1997 Act, and we were told, they were told by the Bahamian authorities that it was not needed, and therefore they can say it's not their fault they didn't get one till the last minute. In favour of the applicants, in favour of granting the interlocutory injunction, is the fact that if it's not granted, that will undermine the interlocutory, that will undermine the application for judicial review. Furthermore, they are not, as it were, unconnected with the premises, with the proposal. They represent groups and individuals who live or carry on business on premises which are very near and will be affected by, and indeed, as I understand it, in many cases are being adversely affected by the development. Furthermore, to a significant extent, the respondents can be said to have entered into the dredging contract with their eyes open, because the proceedings had already, the judicial review proceedings had already been brought, and they had offered a clear undertaking, which they repeated to the Court of Appeal, that they would not start the dredging until they had all the permissions needed. That was an offer they made, it was an undertaking they gave, and it has to be said, as a commercial organisation, they undertook it at their own risks. As it is, because of our concern over this very last-minute permit, we think the right order to make is to grant the injunction. We do say that we consider that the effect of the Act appears to be on the arguments we've heard, as we've indicated, and we do say that while the arguments are very finely balanced, we feel that the best way of disposing of this, the fairest way, is to grant an injunction, but to accord the respondents the opportunity at short notice of establishing that the permit is one that they can rely on, that was given the necessary consideration by the DPP, and if it is a relevant dispute, that they have complied with the conditions set out in the permit by reference to the letters, which such as they have to comply with before they dredge.